Hi, I'm Nikki Eleanor, the founder of Guardian Business Services, and welcome to session 3 in our Back to the Future of Work series. In this session, we're focused on making changes that may detrimentally affect your workforce and also ending relationships that may no longer serve your business. So if you've been watching sessions 1 and 2, you'll have seen that the lovely Jane Dunn has announced a competition. And at the end of this series, we'll be announcing the winner of a workable plan. So what does that mean? So a workable plan is effectively a plan which will enable you to implement all of the things that you've highlighted during the Back to the Future of Work series that you might need to give some attention to in your business. We'll help you pull it all together and create a strategy for you for the next 12 months. So all you need to do to win is to show up, share, like, engage with us, ask your questions, tell us about your aha moments, and we'll be drawing the winner next Wednesday. So without further ado, I'll dive into the session. So as I mentioned, we'll be talking about changes in this first section of this session, and we'll be talking about changes that may affect your workforce and that you may need to plan for that can't necessarily be done overnight. And sometimes that can be overwhelming for employers. So what we suggest is, as a starting point, get a blank piece of paper and a pen and write down a list of all the things that you think need to change in your business. That can be, small things like we need to get rid of our vending machine because it's no longer viable because it's not used and restocked and the contract's coming to an end, to we need to completely restructure a department and that's going to involve consulting with 50 people. So just write everything down. And then next to each of those points that you've written down, write down whether that's an immediate priority, so something that you need to do straight away or it's a quick win, whether it's something that actually is something that needs to be done but needs a little bit more careful planning and perhaps the time is not right just yet, or whether it's something that's a longer term strategy, something that's a nice to have that doesn't necessarily need doing, but you would like to do it in your business at some point in the next 12 months. Once you've done that stage of the exercise, then go through it again and look at whether you need to change the order of priorities based on cost, for example. There might be something that you've put down as a medium-term priority when actually it could be done relatively quickly and it's off the list then. So again, when you're talking about your quick wins, something that's been bugging you for a long time or bugging your staff for a long time could be resolved relatively quickly when you review the changes that you need to implement. So yeah, reprioritize that list and also have a look at the costs. Something that you've determined that you may need to do immediately, you may not have the budget for right now. So that might need to go lower down the list and perhaps be pushed back 3 to 6 months. So that's your starting point, really. Just A4 sheet of paper and do your brain dump and shuffle things around in terms of what you think might need doing and when. So with your quick fixes, have a look at your existing contract of employment. You may have some flexibility in there already. For example, if you're wanting to alter people's duties, you may find that their job descriptions or the description of their role in their contract gives you enough flexibility to be able to do that without having to go through a full consultation process. Have a look at whether the things that you're trying to change are non-contractual, so for example your policies and procedures, or whether they're discretionary anyway. So for example, bonus schemes, you may find that actually your bonus scheme is discretionary, and so actually you're exercising a discretion not to make an award this time round. You don't necessarily need to consult with the staff about that before you implement that change in your business. For those changes that have little or no consequence, well, they're the ones that you're likely to get the least resistance from staff in relation to. And again, they might be quick wins that actually no one's that bothered really, whether you make that change or not. So you may as well get it ticked off your list quickly. And often some of the things that you're gearing up to discuss with staff and changes that you're looking to make, sometimes we wind ourselves up too much. And in reality, we just need to ask the staff. And you might just get a yes, and all of a sudden that matter's resolved and you don't need to give it any more headspace. So sometimes people think that certain categories of workers don't have a voice, they don't have a right to complain. Perhaps they've got less than 2 years service, so can't claim unfair dismissal. Jane referred to this in session 2, really, that we need to be mindful that we don't get caught out, because actually those with less than 2 years service do have protection. 0 hours employees do have rights. You need to look at whether your people that you're looking to make changes to really truly are self-employed. Sometimes employers get caught out by thinking that the quick fix is to let go of all of the agency workers or their self-employed contractors, but then they get caught out because actually those people are neither of those categories of worker, and in fact actually they're employees, or they think they're truly self-employed when in reality they're workers that have minimum rights there too. So it's important to ascertain the employment status of the people that are affected by the changes that you're looking to make. They may have statutory rights, and also they may have contractual rights too. So whereas you might be thinking, well, it's okay, I don't have to give a 0 hours worker any notice, you do. Well, it's okay, I won't give them any shifts in that period. Well, actually, if they're not really a 0 hours worker, if there's someone that's been working regular shifts for years even, which we do come across from time to time, then actually they may have certain minimum notice periods that you should really adhere to, rather than just saying you're given a week's notice and you're not going to get any hours in that week. So as I put on the bottom of that slide, beware of discriminating. Are you selecting the people that you're looking to make the changes in relation to because of a discriminatory factor? Does it happen to be that you're implementing a policy to dispense with part-time workers, and all of those are women with childcare responsibilities, for example? So you just need to kind of just look at the list of changes and who's affected, and just make sure that you're not discriminating against anyone in relation to those changes. So when you've got that big long list, identify the big 3. So the 3 things that you're going to change in the next 3 months. So these are your priorities. These are your key measures that you're going to implement. Find your why. Why do things have to change? It's really important to understand this, because you're going to use this information throughout your consultations, throughout your letters, your ongoing communications, the cascade of information through employee reps, for example, through team leaders, line managers, as they speak to staff about the changes. You need to have a consistent story. So make sure that you've got that really clear before you start to speak to anybody about the changes that you're going to make. Think about what the positive impact will be for making those changes on you. So sometimes we put changes off. People are resistant to change, of course, but actually, if you focus on the positives of, what will your business look like? What will you achieve? Will you make cost savings? Will morale improve? Focus on the positives whilst you're going through the process, because sometimes employers tend to give up halfway when they get overwhelmed with, how hard it feels. So you need somewhere to aim for. And so really just focus on those positives, not just for you personally, but for the business and for the wider team as well. So what we've seen during the lockdown is that quite a few businesses have decided to go it alone, that they've decided to downsize rather than, scale up. They've made changes to their business model and have perhaps become specialist consultants rather than, having a team of people that deliver the services in their business. So for those of you that are Friends fans, you'll spot the pivot reference to Ross with the sofa. Have you pivoted during lockdown? Are you going to be closing teams, departments, sites that you operate from? What do you need to do in order to implement those changes, and how will they affect your people? Have you got new ways of working? For example, we're dispensing with our office, so we'll find somewhere else to come and see you. We might have to come and see you clients at your premises rather than ours from now on. But we've decided that, after almost a year of hardly being in the office, that it's something we don't need anymore. So that means that our staff will work from home predominantly. So we're going to have to adapt and change our ways of working to accommodate that. Draw up your dream structure. So, if you decided to downsize or to reshuffle or change the way that you do things, change your operating model in terms of, how you provide the services, how do you need to fulfill those services? What does your team look like now? So you can draw up an organogram of what your existing team looks like, and then draw up your dream team and what that looks like. And then that'll help you identify what changes you need to make in the structure. So it's not all about dismissing employees, obviously, when you restructure. Sometimes it's a little bit of a reshuffle. So, when you draw up the two structures, as I mentioned, your existing structure and your future structure, you might actually see that some of the people that fit in structure as it is now fit really neatly into some of the new roles that you need in the new structure. So assess the roles first, work out first what roles you need. Don't try and make up jobs for people, that you want to move across. Yes, they may fit, but your starting point should be, what roles does the business need in order to fulfill, the purpose of the business? And then you look at the people in terms of like matching them across to the new structure. If they do neatly match, and you're literally repositioning people and reshuffling them into a different line management structure, then that should be relatively straightforward. Obviously, the complications can apply when you've got 3 people in one department now, and actually you're looking at having 1 or 2 people. So that will then naturally create a pool for selection for potential redundancy. But if it is literally a case of moving people across and shuffling them around, then you could do that relatively easily through job matching without mentioning the R word. Create job descriptions for all of the roles in the new structure. So this will give you the clarity and the confidence in the conversations that you're having with staff about the restructure, because you'll be able to kind of tell them the answers to the questions that they may have about, well, what's different? How does this affect me? And it will show that you've given it some real thought and give them some confidence, that you're doing the right thing and that you're positioning them in the right place in the new structure. And set the expectations for change. So, perhaps if you've had staff that, have been carrying out roles at the moment that, perhaps they've plodded along, maybe they haven't even had a job description. If you're going to go through the pain of a restructure, then, set the expectation that this is a change and that actually people will need to kind of adapt their behaviour. They will need to raise their game, and it's almost like a reset. And plan your process as well. Make sure you plan when you're going to speak to people, who you should speak to, in what order, what time you're going to give them to consider job descriptions, for example. Plan your process and plan for, time in between for employees to take advice and also to, ask any questions that they've got of you through that process. So identify what you want to change. Can you do it anyway? This is really recapping. Speak to your staff, they might just agree. Go through formal consultation if you have to, if that's a change that you need to make, and make sure you get some advice on how you do that properly. And also just bear in mind that if you are going to impose a change on someone, so let's say that they haven't agreed to the change that you're proposing, and you decide that you're going to go ahead with the change anyway, then that is actually a dismissal and you're offering re-engagement on the new terms. So effectively what you're doing there, let's say that you propose that you are going to change the pay grades. And that meant that actually somebody may have to, take a pay reduction. If they're not prepared to agree to that in line with the revised job terms and the perhaps a reduction in responsibilities, then, and they've been with you for 4 years, they've got a 4-week notice period. You would give them 4 weeks notice, 4 weeks and a day later, you'd be offering them re-engagement on the new contractual terms. So just be careful that potentially, if you're going to impose a 50% pay cut, then potentially you're facing an unfair dismissal claim, and that would be difficult to justify. However, if the change that you're imposing is reasonable, you've had meaningful consultation with them, and you're then imposing that change, there is an argument that actually an employee's failed to mitigate their loss if they don't accept the changes after the old contract's ended. So it's really important to get some legal advice at that point to make sure that all your documentation backs up exactly what you've done in that process, just in the event of an unfair dismissal claim. So for those of you that know what TUPE means, I can hear the groans almost through the screen. Yes, TUPE is a piece of legislation that applies where a business is transferring ownership, or there's a change in a service provider, and all the employees transfer on their existing terms and conditions. So let's say you currently outsource your cleaning contract, and you've decided that you're not going to do that anymore and you're going to take it in-house. Potentially, the people that are employed on that cleaning contract may become your employees. Or if you are selling your business as an ongoing concern, then the employees that you have at the moment will automatically transfer to the new employer, once the business sale goes through. So there are obligations in relation to TUPE. If you are the person that's selling the business, or you're the outgoing service provider, you've got an obligation to provide some employee liability information to the people that are taking over. Both parties, the outgoing employer and the new employer, have got a joint liability for informing and consulting the staff about the transfer. So there is no hard and fast rule as to when you have to start that consultation, but it has to be done in good time. So, it has to take place before the transfer takes place. And it's, even though you may think it's commercially sensitive and, you couldn't possibly do that because, it's going to blow the deal, or people are going to, breach confidentiality, it's absolutely essential that you do inform and consult with staff. And the penalty is up to 13 weeks pay per employee if you do fail to inform and consult with them about the transfer. So that's just something to bear in mind if you're making changes to the way that your business operates, the services that you provide, or if you're, buying or selling a business, then, you have got obligations to your staff in relation to that transaction. So we're now going to move on to the ending section of the employment life cycle. And following on from restructures, often they do result in redundancies. So redundancy is the R word, the hardest word to say. And employers never feel comfortable about making redundancies, understandably, because it affects people's livelihood. But there is a statutory definition of redundancy. It's the only law I'm going to quote at you in the whole session. And basically, a dismissal is by reason of redundancy if it's wholly or mainly attributable to a business ceasing to operate completely. So you're closing your doors, or in a particular place, you're closing a branch, or the needs of the business for employees to carry out work of a particular kind have ceased or diminished. So that means either that you've decided that you're going to stop providing a particular service or product that results in the closure of a department that had staff working on that product, or you've got a reduction in the amount of work volumes, so you need less employees to carry out work of a particular kind. So that's the situation where you have maybe 10 staff at the moment in your sales team, and you decide that going forward, we're only going to need 3 of those. So then that would trigger the redundancy definition because there potentially are 7 redundancies there. When you are facing a redundancy situation, there may be certain circumstances, depending on the numbers of people affected, where you have to trigger collective consultation. You may also have to notify the Secretary of State in advance of potential redundancies if there are 20 or more potential redundancies in a single establishment within a 90-day period. So there's a form to fill in called an HR1 form. You go on Google and search HR1 form, it should come up, and it's a pretty straightforward form for you to fill in. And we do get asked the question, why do we need to do this? We're only a small business. The reason that you have to make this public notification is because potentially if you're unable to cover the costs of redundancy, then the government may have to pick up the tab in terms of the statutory payments that are due to the staff. So it's to help them kind of preempt and budget for, potential redundancy payments. And so it is a statutory obligation for you to fill in that form if there are 20 or more employees in a single establishment. There are also minimum consultation periods depending on the number of staff that are affected. So if you are proposing to make between 20 and 99 redundancies, it's a minimum 30-day consultation period. And if you're looking at over 100 redundancies, it's a minimum 45 days. And that's from the start of the process to the first dismissal taking effect. And just to clarify there, that's in terms of the number of redundancies, not the number of staff that you're consulting with. So if you happen to have, you're looking at 2 redundancies, but there are 20 staff that you need to talk to, that wouldn't trigger the minimum consultation period and the HR1 form. So if you are considering making redundancies that affect 20 or more employees, then there's an obligation to undertake collective consultation. So that's where you would set up an election for employee representatives to represent the affected staff. You might involve the union, a works council, and the failure to go through and comply with your consultation obligations is up to 90 days pay per employee. So again, it's really important to make sure that, you go through the motions really in terms of process if you are looking at redundancies for 20 or more staff. So one of the key things to do, when you're facing a redundancy situation, again, is to think about your business case for why you are looking at redundancies. You'll use that again through your scripts, through your letters, through your one-to-ones, in response to questions that you might get asked. You might produce an FAQ document, but you need to be clear on your business case for redundancies before you start. You also need to get some clarity on who's affected. So there's terminology in the statutory legislation regarding pools for selection. So what that means is, let's say you are looking to close a branch of one of your shops. And so your pool for selection is all employees that work in that shop. Alternatively, what you may do is say, well, actually, there are 3 shops that are really close to each other. So what we're going to do is we're going to pull all of the staff that work in all 3 of those shops, because they've got interchangeable skills and experience. And the aim is to kind of retain the best employees, if once you've gone through a scoring exercise, within the business. So you could define your pool as all those that work in the shop, or all of the employees that work in all 3 shops that carry out work of a particular kind. Plan your communications. So how are you going to communicate? When are you going to communicate? How often? It's important, particularly if you've got collective consultation, once you've set up the elections, how are you going to communicate with the employee reps? How are they going to communicate with the staff that they're representing? It's just important to have a communication strategy, and that will also factor into your timeline as well. So you may be thinking, okay, well, this is pretty straightforward and we'll get it done in a week. But actually, when you start factoring in the communications, it might take you a little bit longer. So it's important to plan ahead. And also factor in your costs. So if you go through, a modelling exercise in terms of, okay, well, we've got 20 employees, we're looking to make 10 redundancies, we're going to use some selection criteria to determine who are the 10 that we're likely to retain in the business and which 10 are at risk. When you look at that, you may then determine that, oh my goodness me, the 10 that are at risk have all got 15, 20 years service and 12 weeks notice each, and the business can't afford to pay their redundancy at that level. So in that circumstance, cost may be a factor that you could include in your selection criteria, and that perhaps they score a lower score if they are a high cost to make redundant. So it's important, because then you'll need to factor that into your process at the end as to how you're going to make payments, when you're going to make payments. It could be that you want employees to work their notice periods, or you'll put them on garden leave, so you can stagger the payments over the garden leave period. And then you may want to request from employees that they take their redundancy entitlements in instalments. So, they're all factors to consider before you get cracking. Think about who's going to run the process. So it's helpful to have a project manager, someone that is connected with everybody to ensure consistency in terms of the managers that are carrying out the consultations, in terms of the scoring processes, the sharing of information. We need somebody that has a consistent voice and can manage the process for you. Consider where you're going to allow employees to volunteer for redundancy. So, it's not compulsory to do that, but actually, if you say, you're going to open it up to your workforce and you're going to allow people to volunteer to go, and you get, enough people that step forward, you might need to, incentivize people to do that, offer them a little bit extra if they are prepared to go voluntarily. But if you get enough people that volunteer, that might help you to avoid a formal consultation process. So it's worth thinking about. It's up to you whether you want to offer statutory terms. There are statutory minimum terms based on age and length of service, and their weekly pay. Or you might want to offer enhanced terms. So you could offer redundancy terms based on their actual pay rather than the statutory cap. That's at your discretion, but something to think about. If you're looking at alternative roles that are available for those that are at risk of redundancy, you've got an option to put it out for interview. So to say, everyone who's at risk can express their interest in a particular role, and they can go through an interview, and the most impressive candidate gets the job, and the others unfortunately are then redundant. Or you could say, well, okay, let's not put people through an interview process. Let's come up with a selection matrix where you'll be looking at, objective criteria to score people against in order to determine who's at risk with the lowest scores. So, you have options there in terms of alternative roles and how, you distribute those roles amongst those that are affected by the redundancy process. It's up to you whether you want them to work their notice or not, or you can put them on garden leave, as I mentioned. So you can pay in lieu of notice, so their employment would end immediately, and then you pay them up what they would have been entitled to had they worked their notice. And have a look at suitable alternatives to redundancy. So, there may be some debate about what's a suitable role or not. You may think something's suitable, an employee may not. So, have your business case ready as to why you think that's a suitable alternative role. And there are various options there as well in terms of if you do offer a suitable alternative and an employee unreasonably refused that, then potentially, you may have some options in terms of non-payment of their redundancy pay because of their unreasonable refusal to accept a suitable alternative role. But again, take legal advice on that situation. You don't want to get into arguments with employees about what's suitable or not without having the facts and the law behind you in terms of understanding what you can and can't do. So where you've got no money in the coffers, redundancy costs can be a factor in selection criteria, as I mentioned. You can ask employees to accept stage payments. There may be financial assistance from the insolvency service. So if you are in financial difficulty and the business is perhaps reach the stage where it's no longer viable and you can't afford to pay the statutory redundancy and notice payments, then it's worthwhile having a look at that link. There's some guidance there for employers and also how employees would then claim their statutory entitlements from the state. So we've created a guide to redundancy and I'll put the link to access that in the Facebook group. So grab that while you can. It's written by our legal team, and there is some practical advice and considerations for you in that guide. So yeah, grab that while you can. So I thought I'd cover some other types of dismissals other than redundancy in this session. And really just some basic principles that in order to avoid an unfair dismissal, the best thing you can do is be fair. So that's in terms of your process, in terms of your selection, in terms of your criteria, your communications. You know, if you can look at it and say, right, I would happily stand in front of an employment judge and, you know, stand by my decisions, then, you know, that's what you need to aim for. There are only 5 fair reasons for dismissal. One of them is misconduct. So that's, you know, that they've had their hands in the till, for example. Incapability. They're not capable to do their job either because of ill health or because of, you know, performance gaps. Redundancy that we've covered. Illegality. So that's a quirky one, really. So that happens where let's say you're employing a driver who loses their driving license, then, you know, it's illegal to continue to employ them as a driver. And some of the substantial reason. So even though that sounds quite wide, it actually only applies in like very narrow circumstances. And one of which is where, you know, there's been a huge falling out, personality clash. 2 employees have been having an affair, and you know, now it's affecting their performance at work, and now they've split up and one of them has to go. We've had that situation. So, you know, there are only 5 fair reasons. And so your reason for dismissing people has to fit within those fair reasons. When you're thinking of dismissing someone, question yourself as to what's the real reason for dismissal, and use that. So we're often asked, isn't it easy just to make them redundant? No, because as we've explained, you have to go through a formal process in order to go through a fair redundancy. And so, you know, sometimes actually it's much easier to call it out. You know, if somebody is performing badly, or, you know, you've given them loads and loads of support and gone through a fair process up to date, then performance is the reason why you're letting them go, not redundancy. And actually, if you start to go through a sham process because of a sham reason, you often get found out anyway. So it's easier just to be upfront and follow the right process that fits with one of those fair reasons. Just a point to note that you can consult with employees, hold disciplinary hearings, grievance hearings, and serve notice on employees during furlough. However, you know, their notice period then has to be paid at full pay, and also you can't claim for any furlough pay under the job retention scheme for their notice period. So that's a change that was introduced in at the end of last year. When you are dismissing employees, I would suggest that you do this before you dismiss. So have a look at the contract and find out what they're entitled to. What notice, you know, whether you've got the right to pay in lieu of notice, what pay they're entitled to, any benefits, whether they continue during the notice period. Have a look at if there's any commission due or any bonuses due, and what your contract says about whether they're still payable if an employee's under notice. So, you know, just get your facts straight before you have the conversation with the employee. So follow a fair process and provide written reasons for dismissal. You know, it's common courtesy, aside from it being a legal requirement, that, you know, you should really provide written reasons for dismissal, so that, you know, employees can come to terms with that. And if they want to appeal that decision, then, you know, that they know what they're appealing against. If you just say your employment's ended and thank you very much, and they want to appeal it, they'll just send you an equally bland letter of appeal that says, I want to appeal this decision. So, you know, at least have the courtesy and decency to tell them why you're letting them go. So resignations. If you receive a resignation, it's worthwhile speaking to the employee to dig in a bit deeper into the reasons. Check that it's not a heat of the moment resignation, that it's not in response to the employer's conduct, that it's not really a grievance, and that they're not whistleblowing. And if you think it is any of those things, then you're going to need to take some more action. It's not as simple as just accepting their resignation and letting them go. We'll cover that in a moment. So see if you can resolve the issue, the underlying reason for the resignation. Perhaps persuade the employee to reconsider their decision and perhaps retract their notice. Check the contract again, so termination provisions, confidentiality, what happens with company property, intellectual property rights, who owns what, and also have a look at conducting an exit interview. They can be very insightful in terms of an employee's reason for leaving your business, and it might help you, prevent the next employee that replaces them from leaving the business for the same reason. So again, you need to write to the employee to confirm the termination arrangements and also their entitlements. So, that must be done in writing. It's not okay just to kind of verbally accept it. So whistleblowing, this is a hot topic at the moment, particularly in light of the lockdown and the health and safety measures that have had to be introduced because of the coronavirus pandemic. And, we're finding that employees who are nervous perhaps about returning to work are making anonymous tip-offs, are complaining to the HSC or the local authority, that their employer is breaching the regulations and health and safety measures. So whistleblowing is where a worker passes on information about wrongdoing, and it's either in relation to criminal offences, failure to comply with legal obligations, miscarriages of justice, endangering someone's health and safety, so that's the big one at the moment, damage to the environment, or covering up wrongdoing in the above categories. So that's what is meant by whistleblowing. There has been a surge in whistleblowing complaints and claims. Quite a few employees have come forward and reported anonymously that their employers are fraudulently claiming under the furlough scheme, that there have been breaches of health and safety, and there is some debate as to what constitutes serious and imminent danger, as to whether it's a legitimate whistleblowing protected disclosure. That's the word I was looking for, the phrase I was looking for. People who do blow the whistle have legal protection from being subjected to a detriment, victimisation, and also dismissal as a result of making their protected disclosure. So ordinarily, an employee would make their disclosure directly to their employer first, give them an opportunity to put things right, but they don't always do that. So sometimes employees go straight to the regulatory bodies. So when you get your resignation letters, have a look at if an employee is citing the reason that I'm leaving is because it's an unsafe working environment. You may need to treat that as a protected disclosure and invite the employee to a meeting to discuss that in more detail. It might be that they've, perhaps got the wrong end of the stick, and you could reassure them, put their mind at rest about the measures that you've got in place, and the relationship may be salvageable from there. But what we'd say is, with any resignation letter, look at whether there's more behind it and whether you need to say, this is a grievance, okay, let's invite them to a grievance hearing, or this is a protected disclosure, let's invite them to a meeting to discuss that. There is an increased risk of dismissing someone who's raised health and safety concerns because of that, and there's no cap on the compensation payable as well, so just be careful. So if you're an employer and you've received a phone call from ACAS, return that call. Listen to what they've got to say. Have you messed up? Often as employers, we feel aggrieved, when we find out that an employee's contacted ACAS rather than speaking to us. And actually, that sometimes we dig our heels in and, draw the battle lines, and I'm not going to offer them a penny for that. But actually, sometimes we need to step back and say, yeah, actually, we messed up a bit there. If you did mess up, resolve it and move on, and make sure you don't do it again. And if you haven't messed up, then in that situation, explain your side and back it up. So, actually, if you're being accused of not consulting with an employee over a TUPE transfer, dig out your letters, dig out your meeting notes where you did, and share those with ACAS, because ACAS are an impartial service, and they can share that information and perhaps get the employee to understand your perspective and that perhaps the value of their claim isn't as high as they thought. An employee has to go to ACAS for pre-claim conciliation before they lodge an ET claim. So when they lodge a claim, they have to put a reference number that's given to them by ACAS. So it's really important that if you do get a call or a letter, email from ACAS, that you do take it seriously. So if you want to potentially have a difficult conversation with an employee and you're not ready to go through a process that involves other staff, so I'll give you an example. Let's say you have an underperforming manager and you want them to exit the business, but rather than have a consultation process that involves disrupting 3 or 4 managers and making them all feel unsettled and feel like they're at risk of redundancy, for example, the issue is that there's a poor performing manager, perhaps with a toxic management style, then actually it might be better to have a protected conversation with that manager rather than put everybody through a redundancy process, which will just be a sham. So also, if you have got an employee that's raised a grievance, or that they've gone off sick with work-related stress, or they've contacted ACAS, or they've actually lodged a tribunal claim, you might want to have conversations with that employee to negotiate exit terms. They're called protected conversations during employment, without prejudice communications. You might have heard that terminology that the lawyers use to protect their correspondence between the parties from being disclosed to a tribunal if it does end up there. But if you are looking at having those conversations, then take some legal advice beforehand. Plan what you're going to say, how you're going to say it. There are certain legalities, there's a framework around that conversation and time limits that you have to give employees to consider offers that you might make to them. So ultimately, if you've negotiated an exit with an employee, then the next stage would be to formalise that in a document called a settlement agreement. Rather handily, we've created a guide for you to exit negotiations and settlement agreements. The link will be in the Facebook group, and that should give you enough of a flavour of the importance of getting it right and the framework for the process. So skipped one again. At the moment, the tribunals are struggling, obviously, because of the pandemic. There is a backlog of cases, and there's a risk of more cases following, particularly as the furlough scheme ends, and there are likely to be more dismissals. Unemployment figures are soaring, and what we're finding is that the employers that have not followed the advice, not sought the advice in the first place, they've been winging it, or they've been cutting corners, are the ones that are getting caught out unnecessarily in our view. So the tribunals are inundated with claims due to the coronavirus. We know that some cases are being listed for the middle of next year. So if this is something that you're going to have hanging over your head for a long period of time, every time that we get in touch with you to say, right, okay, we're at the next stage where we need to put the bundle of documents together, we need to draft the witness statements, we need to put together a list of agreed facts, we've had the letter from the other side solicitors. That process is wearing, it's really draining. So what we'd say is, let's get it right first before you start making any changes, to avoid all of those pain in the arse communications in the event of a tribunal claim. It's free to make a tribunal claim, and also quite a few employees have got legal expenses insurance, which means that that they under a house insurance policy, a mortgage policy, it might have legal expense insurance tagged on, and that means all their legal fees in connection with suing you are covered. Employers obviously can have legal expense insurance, and we offer that as well. So if it is something that you want to explore further, then get in touch on that. But what we're saying is that actually lots of employees have got nothing to lose by making the claim. So just don't let yourself get caught out. Desperate times, high unemployment lead to desperate measures, unfortunately. And also a dismissal can affect an employee's ability to obtain benefits. So, sometimes you put people into a corner where they've got no choice to fight or try it on. So we're on the final countdown out of the final lockdown, hopefully. We've got no direct guidance that's been issued on when to return back to the workplace for those of you that, aren't fully up and functioning yet. And really, it depends on a case-by-case basis, depending on what your business does. Some businesses obviously, have been told to close, and so they've just got to await the dates when they can reopen. Other businesses, may decide that they're going to continue working the way that they are because, they haven't got the resources or the time to put in place the measures that they need to protect their workforce, coming back to work now. We're hoping that 21st of June is a watershed, that if all the tests have met, all restrictions will be lifted, fingers crossed. It's anticipated that all adults in the UK will be vaccinated by end of July, which is fantastic, and they seem to be on track for that. 30th of September, that's the date that the furlough scheme is due to end, and there is some tapering down, as Jane mentioned in the previous session, in terms of the amounts that employers can claim. And this is a big hot topic, really, because many surveys show that employees want to continue to work remotely at least half of their working week. So, we're seeing that flexible working requests, will be coming in thick and fast, and employers will have to have some pretty convincing reasons why, it doesn't work if it's worked for the last year. That doesn't mean that they have to necessarily accept them, and it is just a right to request, not a right to have flexible working. But we think that that's going to be a hot topic in the next year or so. So what have we covered today? So we've covered quite a lot, really, a lot of the heavy stuff in terms of making changes that affect your workforce, and also ending relationships, and how to do that properly and fairly. So we've got a bonus session for you next Wednesday. It's a live session with me. And in that, what we're going to do is we're going to pull together all of the information that you've written down whilst you've been going through the Back to the Future work series, and we're going to work through it together. We're going to create a plan for you. Let's create the framework for a workable plan that you can then go and implement all of those changes and manage all those HR issues. Redefine how you do HR and your performance standards. So it's a practical session this time, rather than a teaching session. And if you turn up live, there'll be some extra bonuses for you. So that's it. Thank you very much for listening to me, and I look forward to seeing you on 31st of March at 10 AM for the Workable Plan Workshop.